Maureen, welcome. Really appreciate you joining today. As you know, in the world of Zoom webinars, the first couple of minutes involve maximizing awkwardness by having you and I sitting here for at least a couple of minutes while folks virtually join our attendee room here. So we're going to give everybody a few minutes to join, and we have an absolutely terrific group of attendees and participants who I can already see and recognize so many names in our community. But for now, you have to imagine that we're sitting up on the dais of a virtual conference, just waiting for folks to kind of walk into the room. And we'll give it just a minute more here before we all jump in. But welcome, and I hope you've been doing well, all things considered here, Maureen. It's certainly a strange time, for a ton of different reasons.
Thank you. I'm really excited to be here to talk about these issues.
Terrific. Okay, well, it looks like we've got a great set of folks who have now joined the room. And so let me first of all start by welcoming everyone here to our webinar. This is part of our Privacy Conversations series brought to you by Wirewheel. And in these discussions, we bring some of the leading minds and policy leaders in the areas of technology and privacy to talk with our community of issues of interest. And we've had subjects, Maureen, just so you know, on everything from SHREMs to AI to national security policy. We've obviously spoken about COVID a lot with folks in our community. And on behalf of our entire team here at Wirewheel, we're just really delighted to have you here. For those of you who are joining us today, we have Maureen Mahoney, one of the leaders on policy at Consumer Reports, who's been closely following the area of privacy and data protection. And we're going to be talking to you today about the new CPRA, the new law that was passed in California just last week, although it seems, Maureen, like it was years ago. It seems like it's been a a little bit more than a week. We're going to be talking about the law, what it changes, and where this could lead in terms of our community here today. But we always like to start our sessions by just getting a little bit of an introduction from our speaker. And you've been so active in this community. I wondered if you could just tell us a little bit about yourself and how you got into following this particular policy area.
Sure. So first of all, thanks so much for having me. I'm really excited to be here. I am a policy analyst at Consumer Reports. In normal times, I'm based out of our San Francisco office. And at Consumer Reports, many people are familiar with our magazine and our testing. What fewer people know about is we also have an advocacy wing where we push for strong consumer-facing protections, laws, and rules in a number of areas: food and product safety, financial fairness, and digital rights. And the last one is the team that I've been working on. For many years, we've been fighting for privacy legislation on the federal and state level. And it's been pretty exciting being based in the California office, where we are seeing a number of developments in the policy space. So we've been active in pushing for stronger protections with the CCPA. And we've also been looking at the CCPA itself, having consumers test it out and see how well it's working for consumers. So I've been really lucky to, again, be based in California, and that's kind of naturally drawn me into some of these debates over privacy in that state.
Yeah, and Maureen, I mean, having watched that just from the policy side, I mean, this area of privacy has developed so quickly into a multidisciplinary area that touches all kinds of areas. What was your first step into it? Was it literally on a privacy or consumer rights side, or how were you all looking at it that got into that?
Well, I mean, I've been working on a number of different issues at Consumer Reports, but as privacy came to be a more important issue, particularly for consumers, that's how we decided that we wanted to get more involved in that space. And again, being in California, um, we heard back in 2017 that Alistair McTaggart was considering putting forth a ballot measure to advance privacy protections in California that ended up becoming the legislative deal in 2018 with the CCPA. And then ever since then, it's been a fight between advocates and industry to see what the final rules would be in implementing the CCPA. And that fight hasn't continued. We've seen Prop 24 be developed and go into effect. So I think it was just, again, the political battles in California that drew us in, and then increasing consumer interest in protecting their own privacy.
That makes great sense. And obviously, Consumer Reports has been out in front on a number of issues when it comes to consumer privacy. Just before we hop into the CPRA, what have you been seeing in terms of how this has been developing and moving with the first version of the California law, CCPA? In other words, did you see things really change? And as you've seen them change, what has really stood out to you in this last year, year and a half?
I think the biggest thing for us is a key motivating factor for privacy legislation is giving control over the sharing of their information for targeted advertising. And that information, sometimes very sensitive, being used to deliver ads to consumers. So our understanding of the CCPA is that one of the main goals of that legislation was to give consumers control over that. And we were kind of taken aback as the CCPA went into effect, seeing that some companies were putting forth an interpretation of the CCPA's definition of sale that meant that the sharing of that information for targeted advertising was outside of the opt-out. So a lot of our focus of the past year has been calling on the Attorney General to clarify that it does fall under that. Working with Mr. McTaggart to, suggest language to help ensure that it's covered in Prop 24. And that was a big motivating factor for our eventual support of that measure. So I know, other groups focus on many different things, but this was an issue that captured a lot of our attention over the past year or two.
And that's an issue that comes up almost every day with everybody in the country. I've been struck even watching, my kids raise that up when they see it the other way. In other words, you can see them worried. They might use the word creeped out or something like that, that they look for something and then suddenly they start seeing ads on a related subject. So it is a big issue, in the country on that one issue. And you've probably seen the level of focus at all of the tech companies on, the deprecation of third-party cookie tracking and so forth, which is part of the same movement. Now, there was a fair amount of language on this issue in the original CCPA, but there was additional language on that issue under CPRA. So if you wouldn't mind, for our participants here today, would you mind talking a little bit about how that has evolved? And in your view, what does it mean under CPRA with respect to retargeting and targeted advertising? And I might add one more thing. We have just a phenomenal group of attendees, as I said, who've joined. And I know both Maureen and myself really benefit when we can hear from you and you can ask questions and we can actually respond. So please post in the chat any questions we can answer about any of these subjects, CCPA, CPRA, retargeting, any of it. And we'd be happy to cover them here today. So we look forward to hearing from you. Maureen, back to you. So between CCPA and CPRA, what is your view on what it means to targeted advertising and say the do not sell experience?
Sure. So, what we've been seeing when we've been doing opt-out requests under the CCPA, going to companies like Amazon and Spotify and Starbucks, we'll try to opt out, but they'll say, "Oh, we don't sell your information, but we do share it with our advertising partners in order to target advertising to you." So that's been pretty frustrating. Most of the protections in the CCPA with the respect out are triggered by this opt out of sale. And it is a fairly expansive definition. It goes further than just the exchange of money for data, but also for valuable consideration. However, some companies have argued that the sharing of data in order to deliver targeted advertising isn't captured by this word sale. So that's been an issue. There's also been questions about the service provider exemption. Sharing information with a service provider isn't covered by the opt-out. Some are claiming that you can develop a service provider relationship with ad tech platforms in order to deliver ads on other sites. And the way that CPRA deals with this is by creating this new category of data sharing with respect to cross-context targeted advertising, and saying that consumers can specifically opt out of that. It also removes cross-context targeted advertising as a permissible business purpose in the service provider exemption. So I think it's pretty clear that this would enable consumers to opt out of this. However, it is all very complicated and a lot of these processes are very complex. So we'll be definitely looking at how it gets implemented and see how it's working for consumers.
So, I mean, if I were to simplify this when I'm listening, both under CCPA and CPRA, it sounds like the view that what we're talking about is that when a consumer came to opt out of the sale of data, in from what you've been saying, this would mean that a company should no longer be retargeting them on the main platforms. That would be true under both CCPA, but clarified by CPRA certainly as it goes into effect. So if I'm making sure I get this right, for the folks in the community, what that means is if a consumer goes to a website, say a consumer website here at the holidays, and they say, do not sell my data, that company should no longer be retargeting that person on Facebook. Is that a simple thing in terms of the way you see it?
Yes, that's my interpretation of it.
Got it. And I've seen some of the platforms. I don't know, Maureen, if you've seen it, but for example, Facebook had released their limited data use API, the LDU, in order to help companies send that signal to Facebook so that you could opt out as one individual. Some of the other platforms are still working on that, or have said, hey, there's that might be on a particular company to do. Like so do you have a view on how platforms should be accommodating that as well? I mean, how does if you're a consumer product company right now and you are in fact retargeting on some of the major platforms, where are you seeing it from an implementation perspective? In other words, is it there at this point, and are you seeing platforms support this approach?
I'm not sure. I haven't been able to look into implementation in that respect. I think what's important to us is to make it easier on consumers to opt out and express their preferences. The CCPA already puts a lot of responsibility on consumers to go to every single website that's collecting and sharing information about them and opting out. And sometimes those processes can be really complicated. Sometimes consumers give up after, one opt out. So, making sure that consumers know what their privacy rights are and being able to express them easily, that would be our biggest concern.
That makes great sense. Well, let's come back to that technical side in a minute, because one of the things we noticed is Consumer Reports is one of the first companies that were also supporting the global privacy control standard, which we can come to in a while, which I suspect is on that same issue. But let's step back for a minute. On just CPRA, understanding that our attendees today are, probably more on the privacy side and helping companies kind of get compliant. What are the major, say 1, 2, or 3 things that companies should know have come with that new CPRA from your perspective?
Sure. So again, these new controls over data sharing for certain purposes are really important to us. We're also really interested in the expanded data security requirements, putting email address and password that would allow entry into an account under the um, CCPA's data breach private right of action, and just in general expanding data security requirements to additional categories of personal information, and the creation of this new agency that will be in charge of issuing rules and enforcement of the CCPA. I think that's going to give strong teeth to whatever provisions that are put in place by CPRA and will strongly incentivize companies to come into compliance.
Again, I think that's spot on. What we're also seeing, not only is there going to be some critical needs in terms of making sure you give a clear path for somebody to opt out of the sale of data and then stop the retargeting. And that's been a technical solution we have actually been putting in place, Maureen. Like how you actually do that with the major platforms often involves either a technical solution into some API or cutting off of the firing of a pixel to make sure that you're not retargeting. So I think that'll be a critical item. I totally agree with you. Some of the CPRA amendments are going to change those other examples you gave. The other major area that CPRA really brings is, for the first time in the United States, you have the critical compliance documentation requirement and the creation of the assessments and the ability to have an audit record is a huge change, right? We saw how much it affected companies doing business in Europe to create kind of the privacy operations program. And this is the first time you have that legal requirement specifically in the United States, because other than that, most of the CCPA was focused on do not sell and access and deletion. So that is a huge change. In my view, having a data protection agency that's focused on this issue is also going to change things in a huge way going forward, because again, that has not existed in the United States in the way it has existed in other parts of the world.
Yeah, and hopefully this new agency, I think, will have more resources in order to give specific guidance to companies. I know that's been a frustration with some companies, that in Europe they've been able to get more of that, but in California, the AG is so under-resourced and you just have a tiny corner of their office working on privacy. So hopefully that agency will have benefits not only for consumers in providing strong teeth with respect to enforcement, but also companies looking for guidance about how to honor some of the tenets of this very long and complicated legislation.
Totally agree. Totally agree. But even having somebody whose whole focus is that and looking at developing that entire relationship, given how many companies are covered by CCPA, it almost has the ability to set a standard in the United States, much like the way California did it with emissions. If you wanted to sell a car, you weren't building one car for California and another car for the rest of the United States. And so by passing it on a state basis, California was able to help drive a lot of the environmental improvement on emissions in that way. And you can kind of see that happening just as a practical matter with companies that will be under an audit requirement, a documentation requirement, a requirement not to retarget to somebody who's opted out. You can kind of see that moving across the country pretty quickly because companies have to do it anyway. So I guess I'll ask you this from your perspective. How do you see CPRA and CCPA in terms of developing or moving other state laws or even national legislation in privacy?
That's a good question. I know one of the motivating factors for CPRA, for Mr. McTaggart, was to try to make CCPA a little bit more consonant with GDPR for companies that have already put a lot of work into coming into compliance with GDPR, try to make it a little bit closer and greater harmonization. Um, in Washington state, you've seen legislation introduced several times. I think this would be the third year that the Washington Privacy Act will be introduced. And you've seen that developing on the work that's been done in California. Some of the mistakes that may have been made with CCPA when you were trying to hammer out this compromise in a month or so, finding areas of agreement between consumer advocates and companies. And you see what's in CPRA being a little bit more consonant with what's in the Washington Privacy Act, with respect to these risk assessments, for example. So I think that we are going through a learning process. We are getting closer to an idea of what works both for consumers and businesses, or at least I hope so. I think that will help encourage the possibility for legislation in other states and on the federal level. But it's going to be tough because ultimately these are pieces of compromise legislation. They don't have everything that consumer advocates want. They don't have everything that industry wants. So it's hard to find too many folks kind of in the middle pushing for this type of legislation. Oftentimes it feels like there's more opposition than support. I think that's going to be a potential challenge. And on the federal level, kind of people digging in their heels about preemption and private right of action. I think if that continues, then that could be a roadblock to legislation.
Yeah, federal legislation, as you know, has been very tough. Very tough. I worked on that in the last administration, the Obama administration, and you just see so many different groups coming to the table, but with very strong views that are hard to compromise around. When you watch, for example, one thing for me, almost no matter which way you look at it, the fact that Alistair McTaggart, who we've had on this series several times, the fact that he got it done, given the different things, is fairly amazing. I mean, just to get something across the line here. When you're an outside observer and you watched what you would think are, one would think of as normally advocacy groups oppose CPRA, that was interesting, right? To see it, because there were a number of major advocacy groups who are pushing for privacy legislation oppose it. And then you've seen, as you mentioned, Washington's law has failed 2 or 3 times, but it's been, if I understand it right, primarily because of the private right of action issue. And in the absence of a compromise, they've had no law. So that, you end up with some questions about, is it better to have no law or to start with something? And I don't know, do you have a view on that, on how we get there in that kind of a charged atmosphere?
I think it's very difficult. As you said, we ran into this issue on CPRA, where we had a number of groups, some of whom are our closest allies, actively opposing that measure, while we and Common Sense and Consumer Watchdog, some other groups came out in support of Prop 24. And I think their concern on the no side from the consumer advocacy community is that incremental progress would preclude the more sweeping legislation that they would prefer, and that in many ways we would prefer too. The CCPA doesn't achieve all of our goals in terms of being privacy protective, but my point of view is that we've been fighting for privacy protections for years now. I don't think we'll ever get to the point where it's perfect. And we learned that with CCPA. We did have mistakes with CCPA that we're working to address. So I think that you need to move forward, put protections in place, see where the problems are, and keep fighting for progress. Otherwise, in the long run, we could keep pushing this off forever.
I think that's a very thoughtful view. I understand too why Well, and that does give us a good, segue here, Maureen, because as we talked about, there's some pretty important developments in CPRA even outside of the few that we talked about. And some of these items were the subject of a lot of uh, criticism, support by some of the advocacy groups that you saw. So, for example, there was this pretty significant amount of discussion around pay for privacy as baked into the original CCPA. The idea that one can incentivize somebody to use a service in exchange for information or pay a different fee. Um, Obviously that is the law as it is under CCPA, and there were some amendments that came in. Um, do you have a view on that provision, for example, in terms of, whether it should have been changed or further amended in CPRA? And then I'll come to other questions that came up, like around digital redlining or automated decision making. But did you have a view on the pay for privacy side?
Yeah, that's actually been a really important issue for us. We do take a pretty strong position in that we don't think consumers should be charged for exercising privacy rights. And Consumer Reports actually did not formally support CCPA back in 2018. And one of the main reasons why was this contradictory language in the CCPA that could have allowed those forms of discrimination. And we have fought in the legislature against efforts to widen that provision. With respect to Prop 24, I know a lot of groups were concerned that it would worsen those provisions. We viewed it simply as a missed opportunity that CPRA did not permit any more of that than was already permitted under the law. It was simply clarifying that loyalty programs that are consistent with the title are permitted, which in our view was already the case. So we'll continue to advocate for strong protections in this respect, but it wasn't something that affected our position on Prop 24.
That makes, I get it. And by the way, so I made a mistake, and the actual questions should come in, Maureen, via the Q&A feature, not the chat. So we have a few that have come in. One of them is, where can we find the latest version of CPRA? And our team will actually post that right in the answers so that everybody has it. So we'll make it easy on everybody. Here's another question. If a company is thinking about how to actually implement this new law, do you have some guidelines or things they should be prioritizing, Maureen, in terms of first step things to look at? I mean, obviously it sounds like really thinking through a solution on retargeting has to be high on your list, especially if you're a consumer brand. So maybe you could start there and give maybe the one or two top, 1, 2, or 3 top things that a company should think about.
Sure. So I think another goal of Prop 24 was not to completely upend what CCPA was already trying to do. So companies that have already put a lot of work into coming into compliance with CCPA shouldn't be thrown too much for a loop. I'd also point out that most of the provisions of Prop 24 don't actually go into effect until January 1st, 2023. So there is a little bit of time to consider compliance, although it's always good to start thinking about how to do so. But again, thinking about ways to make it easier for consumers to exercise their privacy preferences. We've been working, as Justin has mentioned, on this global privacy control, which is browser privacy signal that for the first time would clearly convey a do not sell signal to businesses. So thinking about how to comply with something like that to make it easier for consumers to opt out, I think that would be really important for consumers and any clients who repeatedly expressed that they value privacy and want to exercise their privacy preferences, but just don't know how.
Yeah, and on that, for the global privacy control. So, for example, Wirewheel, we're enabling our customers to ingest that signal easily. just to build it into the platform and take care of some of the standards, because we do want to support companies being able to implement something easier should they choose to go that route. And at the moment, that seems like a good option in terms of standard. I hope, simplicity in terms of what standard is going to be critical, right? Because it's not only the large companies, Maureen, that are trying to comply. You have so many smaller companies that are arguably covered by the law, and you don't want to create a barrier to entry for smaller companies by creating too many technical impediments. So we are in fact supporting that standard as part of our platform and our solutions. But do you mind talking about that a little bit? What was the goal of that, and what does it do? How about that, just to start with?
Sure. So many of the folks who are working on this global privacy control are the same people that were involved in the Do Not Track effort of the 2000s, just to, again, make it easier for consumers who want to exercise their privacy preferences, but not go to every single company and indicate that do not sell provision. The California Attorney General has made it clear that companies must honor a browser privacy signal as an opt-out, but they said it had to be clear that it was conveying a do not sell command, so it wasn't clear that do not track would fit the bill there. So a lot of consumer groups and tech people and publishers have been working together to develop a set of technical specifications in order to send that signal. And it's still in the experimental stage. And I think it would be important for the AG to kind of give their blessing to make it clear that that should be honored as a browser privacy signal. But the support of companies such as your own and others will also be crucial to ensuring acceptance so that it's actually something that's useful.
Well, that's I hear you, and I think simplification, especially where it really does help both, will be really helpful. Here's another question that came in. How will CPRA impact a B2B company? Do you have a view on that? So let's say you're not consumer facing, you're more in the service provider area. You're providing services, SaaS platforms. How do you see CPRA affecting those companies?
Well, I think for those companies, one of the benefits of CPRA is that it extends the business to business carve out that was placed in the CCPA in 2019. It extends it to January 1st, 2023. So it gives kind of a longer exemption period to consider what would be the most appropriate way for those companies to be regulated.
Got it. Okay, that's helpful. Here's another question, Maureen. This is CPRA includes one of the first data protection agencies, as we've talked about. Now, there are models for data protection agencies in Europe, but I suspect there would be a pretty big difference between the way the United States thinks about data protection agencies and the way Europeans do in some ways. Like, for example, in Europe, the DPAs are obliged to investigate every single complaint in some ways, right? That's the way GDPR works. And it doesn't result in, it results in overwhelming numbers of, investigations against perhaps a limited set of resources. So that's an example where you can imagine the California DPA going a little bit differently, right? Because almost always there's some limitation on resources. And in the United States, most of our enforcement agencies don't have a mandatory investigation requirement. They have a permissive. They can decide which ones are priority and where to bring the right enforcement. The other thing that you really see in CPRA is there is a lot of rulemaking to come. I mean, one of the things that's very clear in the statute is it authorizes the creation of an agency. It puts some rulemaking authority in place, but there's a lot more development of a lot of requirements when you think about it, right? So GDPR itself, in terms of what the paper requirements, what the audit requirements, what you're supposed to capture, it took quite a while. And you're going to likely watch a fair number of companies weighing in on what should be required, what does the documentation look like, how does an assessment get captured here in the next year. But do you have an opinion on or a view, Maureen, on how the new enforcement agency is likely to be created and where that's going to go?
I think that they will be looking at the example of Europe and seeing some of the good things and bad things that have come out of it. As you pointed out in CPRA, a lot of authority is delegated to the enforcement and rulemaking body in order to flesh out a lot of the details about how some of these provisions will go into effect. I think that makes sense in a lot of ways because you don't want to have the statute be so rigid and prescriptive that it's completely out of date a year from now. It also makes sense for these bodies to collect a lot of information from the different stakeholders and participants and can hear from companies about what's working for them and what's not working for them. But as a result, there are a lot of question marks about what CPRA will look like in its final form, if it'll ever be final. So I think we have a lot of work ahead of us, and it's going to be important to provide a lot of information to the rulemaking body in order so that they can make good decisions.
Yeah, I agree. I agree. Well, so let's make it, maybe I'll use this, again, if there are questions from our participants, please post them. We'd like to make sure we prioritize those. But maybe I could go through and kind of start bringing together some of the biggest changes in CPRA, some of which we've discussed, and then we'll use this to come back to ones maybe we haven't discussed, Maureen. So on the list I made before, of course, you have the creation of a new California privacy protection agency, right? That is big. It's the first US agency that is dedicated to this. All of us know, of course, the FTC has been heavily leading the efforts on privacy protection, but so have other agencies. As you know, a lot of the banking regulators take privacy and breach response as huge parts of their portfolio. We've seen the FCC step up on that as well. So in my view, at the federal level, you've seen the FTC proceed with their unfairness jurisdiction, but a number of other regulators have been building it into their core requirements. That said, this is the first purely data protection agency, and that's going to be significant. As you mentioned, the expansion of breach liability to cover the email password combos, that's very significant, and companies should be aware of that. The core requirement that we covered earlier, you have to conduct risk assessments. That was a purely GDPR and maybe the Brazilian law requirement. Now you have to do that if you're subject to California law. That means you'll need some kind of way to capture them and a privacy operations approach that a lot of companies have put in place. We've talked about the focus that's got to be at the top of almost every company's list on retargeting. Retargeting is so much part of the normal operating mechanisms for companies. I'd say very high on your list of things to think about today is have a solution to make sure you can take your do not sell requests either automatically or via cookie or via form, and to make sure that you're not retargeting to a person who has opted out of the sale of data. And if I were to add maybe 3 others that we could talk about briefly, in addition to the 5 or 6 that I just covered, I'd probably say the 3 others to keep in mind are that, to talk about that we haven't is, first of all, there's a new creation of some new definitions around sensitive data. This is a very big development. Do you mind telling our participants about that side of it?
Sure. So as you said, it is a big deal. The CCPA mostly provides protections with respect to the disclosure of information to third parties, but and doesn't really have a lot of controls over what companies can collect and do with your data. So for the first time, consumers will be able to say to a company, hey, don't use my sensitive information, which is fairly broad. It's racial, ethnic identity, information about religion, union membership, geolocation, and that's just the start of it to say, limit the use of my information. So that means, don't sell it or share it, but also they couldn't use it for profiling or, in my understanding, for targeting you with ads based on that sensitive information. So that could be potentially very important for consumers.
Yep, that is a whole new thing, and it's worth focus on. And I think there'll be a fair amount of additional explanation of that provision, Maureen. Um, the second is, and we talked about this briefly, there's some clarification around the idea of automated decision making, profiling, digital redlining. Now, we all know that automated decision making or any kind of decision making in many of the areas that are covered by CPRA, like your performance at work, health, you can imagine banking. If somebody's doing any kind of decision making in a discriminatory manner, it's probably already illegal. You can't, in California or in a large parts of around the country anyway, if I'm making a decision and I'm at a bank, I can't make a decision against you or for you based on certain protected categories. It's already illegal. But it's very hard to prove whether there is bias on those same issues when it comes to automated decision making. And just a week or so ago on our privacy conversations panel, we had the founder of the Alexa function, Maureen, who was talking about AI and how it's developing. And so CPRA does create access and opt-out rights with respect to automated decision making in certain critical limited areas. So I don't know if you want to elucidate on that, but that's an area that I think will receive a bit of focus here in the next year.
Mm-hmm. Well, honestly, that has not been my area of expertise, but we really appreciate that there is going to be additional transparency and opt-out rights with respect to this information and how it's used to make decisions about consumers, especially to the extent that it would lead to disparate impact and outcomes. That's something that is concerning.
Yep, it makes sense. And then I'll put these two, although they're sometimes in different categories, but the last one that there are other things in the CPRA, so I don't mean to minimize it, but the other ones that from just a company perspective that companies should probably know on that top 10 list that we've just covered would be, you have to be able to enable a consumer to correct their information. That's now part of a privacy law. And you have to have necessity-based limitations for retention. You can't just keep data that's personal data with no limitation to it. And it has to be based on necessity and kind of the way a lot of privacy laws are developing. Again, from your perspective, I suspect those are really positive developments, Maureen, I'm guessing from the Consumer Reports side of things. And I think those would be my kind of top 10 list of things to focus on if you're a company. Did I miss anything from your perspective, Maureen?
No, I think those are some of the top things that we're concerned about with respect to CPRA.
Terrific. Well, great. Well, so here we're coming to the end of our time together. I just want to make sure there were. I'll ask two final questions. I'll also mention this issue of retargeting and how you deal with it. We're actually having an entire additional webinar just on that one subject with the team at Forrester, led by Fatima Katablu. just to talk about what do not sell and retargeting are going to mean under California law and how you tackle that. And that'll be up on our site here in the next few days. So we'll send that around. But I think it goes to show you that the first issue you identified, Maureen, is probably going to be one of the most important for almost every company here because of how important targeted advertising is in the marketing ecosystem right now. I guess one question I would say, I'll just ask one more, which is, I assume this may have been covered by some of the items we asked before, but where do you see now with what happened with CCPA and some of the federal law going on, where do you see some of the biggest gaps in privacy regulation right now? Do you see it in terms of spreading CCPA to other states? Do you see the need for private right of action? Do you see the need for additional rights? But where are you seeing the greatest need for additional law?
I think the most important thing is having a federal privacy law with baseline protections for everybody in the country. I don't think it's fair that only Californians have these rights to access, delete, and stop the sale of your information. Again, what we do hear from consumers is that they want more privacy rights. And we do really appreciate that a number of companies have said, hey, we'll extend these CCPA rights across the country. But I think it's important to ensure that everyone has these protections. So I'd like to see a federal across the board privacy law offer these protections for consumers. There's a lot of discussion about contact tracing and privacy legislation with respect to that. And in some ways that's been really promising because the Democrats and the Republicans in Congress's frameworks for protecting that data weren't too far apart. So I do see more movement towards consensus about what appropriate provisions might be. And I hope that folks kind of build on that and move forward with protections, not just for contact tracing, but for all data.
Well, Maureen, thank you. I think we covered a number of really, really important subjects, including the top 10 things companies really need to know when it comes to implementing CPRA here with its passage. I really appreciate you joining us today. I look forward to continuing conversations. I hope you'll join us again. This is a terrific set of subjects, and we've had phenomenal participation today. And for everyone else, thank you for joining us on our privacy conversations today with Maureen Mahoney from Consumer Reports. Look forward to seeing you soon, Maureen. Thank you.
Thank you.
Thank you.